Okay, cool. Thanks, Gabby. Thanks, everyone. Okay, so this is the MES as it stands currently. And so it's for different pollutants. You'll see in the background note, if you have time to go through that after the presentation. So there's different standards for different pollutants. The SO2 standard was amended recently in 2020 when it was basically doubled from 500 to 1,000. So this is what the existing plants have to comply with. And this is just the different sections that we'll speak to as we go along. But I really wanted to show this slide to show that there's two different sorts of standards that we refer to. So there's ambient air quality standards that relates to the ambient air, which is basically the air you experience when you step outside. And then you have the emission standards, which is what we refer to as the MES. This is point source standards for different industries or listed activities. As you'll see, this is relating to power stations and usually for those three pollutants, the SO2, the particulate matter, and the nitrous oxide. So I'll just stop sharing for now. And yeah, as Robyn has mentioned, okay, am I still sharing?
No.
Okay. Okay. So as Robyn has mentioned, Eskom has had a long history of not complying with the MES, despite these standards being much weaker than they actually should be. So they're very lenient when you compare them to other countries such as China. And the MES has been amended a few times. So in 2018, it was amended as well. And this is when Eskom submitted its last set of postponement and suspension applications. And as you'll see from the notes, the legislative framework allows for the minister to declare certain areas as priority areas. So when we talk about the HPA, that is a priority area. And it's basically an air pollution hotspot, which experiences very poor ambient air quality because of the industries. So with the Highveld, there's like 11 power stations that are there. There's a SASOL facility and there's like a whole lot of coal mines and industries there. And so the next step after a priority area is declared, the department then needs to publish an air quality management plan, and that will have practical methods or goals that need to be taken to improve the ambient air quality. So for the Highveld, that plan was published in 2012, and I believe it is still in place. They're supposed to develop a second one because it's only valid for 5 years. As many of you will know, there's a lot of literature and evidence of the health impacts of air pollution, especially in the Highveld. So this demonstrated the fact that the air quality management plan in the Highveld has failed. And this is some of what led to groundwork and the Highveld Environmental Justice Network releasing a report called the Broken Promises Report, basically speaking to the failure of the Highveld priority area and that air quality management plan because of the health impact. So basically saying the health impact is a result of that plan failing. And also, as you'll see from the notes, the Air Quality Management Plan the Air Quality Act provides for the minister to be able to promulgate regulations in terms of Section 20, and these regulations should be there to implement air quality management plans. So some of what was said in the lead up to the deadly air case, which some of you might know, is that basically the Highveld air quality management plan failed because there are no regulations in place to implement that plan. And yeah, so that is just some of the background on the advocacy leading up to the deadly air and also on the Highveld priority area, which is important for us to understand the history, the whole long history around Eskom's non-compliance with the MES. So as I mentioned before, the amendments to the MES and the list of activities came into effect in 2018, and Eskom applied for postponements and suspensions of compliance with regards to various of its power stations, about 16 of the power stations. And when you apply for a postponement or suspension, then you also ask for an alternative emission standard, because you're basically saying that you can't comply with the law, with what is basically in that table that I showed in the beginning. Then you ask for an alternative standard, which is weaker and therefore higher. So the higher it is, the more lenient it is. So Eskom asked for this for various of its power stations, and the reasoning or what they always sort of rely on is the fact that, or they say that it's too expensive for them to comply because the pollution abatement technologies are very expensive and they take a long time to be installed. And also they've raised some concerns on the environmental impacts of some of the abatement technologies, especially for FGD, which is supposed to deal with SO2, which is quite a huge problem amongst the power stations. So these applications are all made to the National Air Quality Officer, or the NACO. So she made decisions on these applications in the year 2021. And the decisions can be classified into three. So you have adverse decisions where she flat out refused the applications. And then there's favorable decisions where Eskom got exactly what they had asked for. And then you have what you can describe as a partial refusal. So she would, for instance, grant a postponement, for example, and then give Eskom an alternative emission limit to comply with. But then that limit that she has given them is not what they asked for. So it's still lenient in the sense that it's higher than what is supposed to be in terms of the law, but it's not what Eskom asked for. Eskom asked for an even more lenient standard. So that we classify as a partial refusal in a sense. And then for the suspension applications, she granted all of those applications and asked Eskom to submit decommissioning plans. And we took issue with this because in terms of the law, as you'll see, when you apply for a suspension, you should already have a detailed decommissioning plan or schedule, and they didn't have that, but she still gave them the suspensions. So in the same year, still in 2021, Eskom appealed some of those decisions of the NACO, the ones that were adverse to them, as well as the partial refusals. And the appeals are made to the Minister of the DFFE, which was former Minister Creasy at the time. And then we also, CER also appealed the favorable decisions to Eskom and the partial refusals to Eskom in 2022. We did this on behalf of Groundwork and EarthLife Africa. And so we basically took issue with the weaker alternative emission standards that were given to Eskom, and also the issue of the suspension applications being granted without detailed decommissioning plans. And then for Eskom's appeal, they again raised the issue about the cost and the timeline for retrofitting, as well as the environmental impacts of certain abatement technologies. So then just to go back to our appeal, basically what we're saying is that you'll see in section 11A of the MES, it doesn't allow for postponements to be granted beyond 31 March 2025. So that came with those amendments in 2018, which was supposed to put a stop to rolling postponements and to put a sort of hard deadline to say that everyone should comply by 31 March 2025. But yet some of the decisions of the NACO went beyond that. And that's one of the big things we raised in our appeal. So then after Minister Creasy received all these appeals, she then set up the MES forum. We call it the MES forum, and it's like a whole panel of experts, and they had to run a consultative process. They had some hearings in 2022. I think that some of you in this group might have attended some. And we participated as well at CER and with Groundwork and EarthLife Africa, and then we also submitted written submissions to this forum. So they basically had to look at all the submissions and consult interested and affected parties, and then make recommendations to the minister on what to do on these appeals. So they made their recommendations earlier this year. And basically what they have found, or what they say, is that the legal framework as it stands doesn't give much leeway to Eskom in terms of compliance. So they've now sort of come up with an interim solution, which is Section 59 of the Air Quality Act, which is the section dealing with exemption applications. And they're saying that Eskom can apply to be exempt from the MES, basically. And this is just an interim solution while the minister or the department is supposed to look at how polluters can sort of come into compliance sustainably. And they said that they looked at competing interests. They've mentioned the energy crisis that seemed to be quite a big factor, as well as the cost of retrofitting. Despite Eskom having had so much time to comply, this still seems like, it was found to be very compelling by the forum and the minister. And then also for the suspensions for the older power stations, they've recommended that Eskom should submit detailed plans on decommissioning. And all this is supposed to happen within the next few months. And then interestingly, they've said that if the minister grants the Section 59 applications, she should then impose certain conditions which amount to mitigation measures. So there's stuff in there about ash dams, about health interventions, and improved monitoring and reporting. And then lastly, they recognized a need for regulatory reform because they say there's a disconnect between what the law says and what people or industries can actually achieve. So they've recommended for the law to be reformed, and we'll see what happens there. And then when we come to the minister's decision, she basically agrees with the forum's recommendations. So her decision can be also split into two. She's directed Eskom to submit Section 59 exemption applications for some of the power stations. And then the older power stations, they need to submit detailed decommissioning plans within 12 months. And the reasoning as well there is that, she's mentioned the costs of retrofitting and the time it takes as well. And then she also says that for the suspensions applications, Eskom is not seeking to emit in excess of the existing plant standards, but they only need an indulgence for the new plant standards, which is the standards that need to be complied with by 31 March 2025. So she thinks that, that is slightly better. So yeah, and also in her decision, she mentioned the balancing of competing interests as well. The energy crisis, the health effects, the cost of retrofitting, the socioeconomic considerations. It's actually quite detailed. So yeah, that is the minister's decision. And when it comes to the suspensions, we're not sure what is going to happen after Eskom submits the decommissioning plans. But we do take issue with that part of the decision because we have always said that Eskom was supposed to submit this when they applied the first time in 2018 already. And also the MES does give a deadline for these suspension applications, which is 31 March 2019. So it doesn't really make sense that they're going to submit this like years later, yet the suspension was granted. And then we also disagree that Section 59 applies to the MES or the listed activities because we see this as a regression. Because many years ago, it was already agreed that this section does not apply to the MES. And former Minister Makonyane had already confirmed this in response to an attempt by Eskom and SASOL to apply for exemptions. So this is quite regressive, and we do take issue with that. And then we also disagree with the interpretation of Section 12A of the MES, which is the provision that deals with alternative emission standards. because the minister and the forum says that this section can basically apply in perpetuity, and there's no deadline. So you could it's always just available for polluters to apply for at any time. And we don't agree with that interpretation. It's not a standalone provision, but should be read in the context of the whole MES. So the next steps is that we are taking legal advice from council, and we will try we will object to the Section 59 exemption applications and also look out for the decommissioning plans. Yeah, that is Eskom. Sorry if I spoke fast. It's like a lot of information, but yeah, I'll hand it over to Robyn now. Thanks.
Thank you, Ntombi. Will you put up the MES slide again, please, the first one? Yeah, it's a huge amount of information to summarize. The upshot is from 2018, rolling postponements of the MES were supposed to have been illegal, but now they're relying on all sorts of new interpretations of the law to say why we can still get exemptions. And SASOL's, Eskom and SASOL's arguments against compliance with the MES have been the same since the MES was set, in a multi-stakeholder process over many years from about 2005. It's too expensive, it's going to take too long, there's going to be an energy crisis, it uses too much water, etc. And in fact, very amusingly, in its first attempt to postpone compliance, Eskom said in its background information documents accompanying the EIA process, essentially, that it had to run to get a postponement, that, wait for it, power station emissions do not harm human health, which is very novel and completely contradicted by their own evidence. Okay, so Eskom, so SASOL, like Eskom, has obtained postponements for all three pollutants of concern for its coal boilers. So that's particulate matter, sulfur dioxide, and oxides of nitrogen. Instead of complying with the SO2 MES of 1,000 milligrams per normal cubic meter, its coal boilers can comply with 2,000 milligrams until 31 March 2025. Then they sought further leniency in relation to SO2, relying on this paragraph 12A. Can you show that slide too, please, Ntombi? That Ntombi mentioned, which was introduced into our law without any public participation, and which we would have challenged at the time had we had any idea that it would be interpreted as it is now being. It's extremely controversial, and Ntombi will put it up when she gets a chance, and its interpretation is actually the subject of pending litigation by CER, which involves ArcelorMittal. They've asked for a declarator on what it means. But in short, government and industry, including the MES forum and apparently a legal opinion, which has not been shared, take the view that this is a standalone provision, which is not limited to any time frame. In other words, despite the prohibition on postponements beyond 31 March 2025, which is in 11A of the list of activities, this provision gives industry an out to continue in non-compliance with the MES thereafter with no fixed deadline to meet them. We say, and we is us and CER, Life After Coal campaign, that 12A forms part of the postponement provisions in the list of activities, so that it's very convoluted, I must say, but that it governs the emission limits that will apply during the postponement, and 11A refers to the time frame of the postponement, which cannot be longer than 31 March 2025, and that you have to read them together. Time frames for the postponement and the emission limits that will apply during that time frame can't exist independently of each other. And that, if that provision means that facilities that cannot comply with emission standards for a particular pollutant or pollutants can receive additional leniency beyond 31 March 2025, then the prohibition in paragraph 11A, which is the previous slide, thanks Ntombi, is completely superfluous. It means that every single facility, except perhaps for those that don't comply with any emission standards, can simply instead apply in terms of paragraph 12A, so that these applications are not limited to that deadline of 31 March and or to comply with new plant standards. So what does SASOL say? To support its application for further SO2 leniency, they said due to the size, the complexity of their facility, emission reduction required a holistic, progressive approach that is sustainable and will have positive environmental and socio-economic results. We're talking here about the 17 coal boilers at its Secunda operations, the steam from which is used primarily to produce synthetic fuels and chemicals through SASOL's coal to liquids process, which we all know is the largest single point source of GHG emissions. They say that this complexity is why its solution to reduce emissions should be an integrated one. And it says that implementing this integrated solution sooner than 2030 would not only be technically infeasible, but would place additional strain on the grid. So can you show our coffee slide, please, Ntombi? So it asked to measure its SO2 emissions using a load-based method, which it calls an alternative emission load in terms of 12A, rather than the prescribed concentration-based method that the MES set out. So this is how they explain it. But instead of reducing the SO2 per boiler, the concentration, it will reduce or turn down the total number of boilers, so the load, through boiler capacity reduction, including using less coal. And it says, don't worry, this will achieve the same or a better result. That is their explanation with coffee and sugar and caffeine. They say they can turn down one boiler from 2025, which would reduce SO2 emissions by 4%, and more boilers after 2030. So it says we'd like one load-based limit from the expiry of our current postponement, so April 2025 until 31 March 2030, and then a slightly stricter load-based limit after April 2030. And they said this will result in a 30% emission reduction load by 2030, that is double MES compliance, would also achieve further reduction of particulate matter, of NOx, and also reduce GHGs. They say, look, we've spent billions on emission reduction projects, and numerous studies show that for sulfur dioxide in particular, various technologies are practically infeasible to install in our existing plants, and they have unwanted, indirect, negative consequences to the environment. They'd previously said they could meet the doubled standard for SO2 of 1,000 milligrams with significant effort. We opposed this application in terms of 12A, and the NACWA actually refused it, including on the basis that, as we argue, no further leniency is permitted after 31 March 2025. But SASOL appealed to the minister. They said the NACWA has misunderstood 12A, and that its integrated emission reduction solution with the load-based limit is the best practicable environmental option, which is one of NEMA's Section 2 principles. Once we, Just Chair, opposed the appeal, Minister Creasy referred it to the same MES forum for advice. So in addition to arguing that SASOL's claims, with expert assistance, about load-based emission reductions were incorrect, we stated that the law is clear. No facility can operate in non-compliance with the MES after 31 March 2025. And as Ntombi says, allowing this would amount to a regressive application of the law, essentially permitting indefinite exemptions from MES compliance, which are not legally permissible. And of course, we say an unjustifiable limitation of constitutional rights. We both provided various sets of additional submissions. There was an appeal hearing, and our expert pointed out that contrary to SASOL's claims, granting its appeal would result in approximately 50 to 130% higher negative impacts than SO2 compliance. On the 5th of April, Minister Creasy granted SASOL's load-based limit up to 31 March 2030. She agreed with the MES forum that MES's integrated solution was not, in fact, the best practicable environmental option. She also pointed out that the forum expressed doubts that SASOL would be able to achieve the claimed benefits in the timeframes, but she also took the view that SASOL had met the requirements of paragraph 12A and was entitled to that relief. In short, and in reliance on the MES forum's advice and a legal opinion, which has not been shared, she said 12A is a standalone provision and can be applied to grant alternative emission limits or loads after 31 March 2025. but she only granted that relief up to 31 March 2030 without saying what would happen on the 1st of April 2030. Remember, SASOL had asked for a different standard from April. She noted that SASOL had failed to comply with the MES despite having many years to do so, and said she didn't condone SASOL's continued operation in terms of the alternative load-based limits. She said she shared Just Share and the NACWO's concern about the health risks of SO2 exceedances, and that the additional 12A leniency should be temporary in nature, and the NACWO should exercise her discretion to bring emitters into MES compliance as soon as reasonably possible, to ensure that alternative limits are granted for a limited duration and the indulgence not in perpetuity. The forum recommended that granting a load-based limit subject to a concentration-based one, so that's how the MES measures in concentration, over a defined time period would help to mitigate concerns about granting this indulgence in perpetuity and concerns about the load-based limit allowing emissions which severely exceed the MES. So the minister made her decision to grant the load-based limit conditional on, amongst other things, SASOL being subjected to a daily concentration-based SO2 limit on which she sought input, that it complies with particulate matter and NOx 2020 MES by the 1st of April 2025, and that its continued implementation of its integrated solution and achievement of the reductions in emissions of all pollutants as undertaken in its application and appeal. So part of that was saying, in order to meet our climate change commitments as well, we need to follow this integrated solution. Then, as I say, the minister asked for input on the appropriate concentration-based limit. So SASOL says, well, we'd quite like to retain the 2,000 milligram limit that's in our AEL, which is double the already doubled MES. Just Share reiterated our view that a limit higher than the MES of 1,000 was not permissible, and pointed out that SASOL's proposed daily SO2 limit would allow a substantial increase in emissions. Then we have Minister George's decision, because remember the decision was in two parts. On the 26th of, sorry, can someone who's got their sound on mute? On the 26th of July, he refused SASOL's request to retain that very weak SO2 limit in its AEL and pointed out SASOL hadn't substantiated that request, but nevertheless granted it a limit that does not require SASOL to take any steps to reduce SO2 pollution. He said the limit should be 1,700 for one stack of boilers and 1,400 for another stack. Those were the limits that we pointed out SASOL was already able to meet without taking any steps to reduce SO2 emissions. Nearly finished. So the way forward, similarly to CER, we're also seeking legal advice. We're still missing various documents that we've requested. We're getting a view from council. But obviously the interpretation of 12A is important. We say the current interpretation means that nothing explicitly excludes SASOL or anyone else for that matter from a further application for an alternative load-based limit even beyond 31 March 2030. And we say this is a regressive application of the law and an unjustifiable limitation of constitutional rights. Just to remember that Eskom and SASOL were heavily involved in setting the MES, which were published on the 31st of March 2010 and provided 10 years with a possibility of another 5-year postponement, which both companies took. So for sulfur dioxide, well, in fact, for all three pollutants, not only will they already have had 15 years to comply by 31st of March 2025, but the sulfur dioxide standard was also made half as strict in 2020. Thanks.
Thank you so much for that, Ntombi and Robyn. Yeah, I definitely am still going to need to go over these notes a second, a third time, but then also to condense it as much as I can. But I do think you guys made it as accessible as possible. And I do appreciate the depth in which you were able to go into, given the constraints of time. But I want to maybe just open up. Does anyone have some questions that they'd like to kind of pose to the two, noting that your question does not open you up to have a second question and a third question at the same breath. So think of your question, get it in there, and then fall back in queue. Anyone, any thoughts, any questions, any observations, any comments?
You can just say it sucks.
Well, it sucks. James.
I'm interested to know, I mean, I know, but it'd be good to have a precise quantification. How long has this process, the MES, sort of been going on? So when were the initial standards put out, and how long has it taken us to get to this point?
It's a journey, as the corporates like to say. So it was first published on the 31st of March 2010, after almost 5 years of discussions in a multi-stakeholder process. And in 2010, they said, there's 2 sets of standards. One set we expect you to meet within 5 years, and another set within 10 years. So, and then you could still postpone each of them by 5 years. So since 2010, there's been certainty of the standards that applied at least 5 years later, but you could postpone it, except for SO2, which was made half as strict in March 2020. So yes, 20 years.
Gosh, David.
Yeah, can I ask about the continuity between the two governments, and whether are you facing more difficulty with the GNU than you did under Creasy's role, and just to highlight the change of context and how you can be able to manage that. Thank you.
I'm sure there are others on this group who know about Minister George's recent decisions on power ships, for example. In my view, he was kind of hamstrung in relation to what he could do on the concentration-based limit for SASOL, because Creasy had already granted the load-based limit, which is significant. So he couldn't really say, well, you have to comply with the MES, in my view. But Ntombi, others, I'm sure there's more views on this. It's too soon to call from me.
Yeah, I was gonna say we're yet to test that out, but I've heard that he's quite the economist or a numbers guy. So yeah.
Creasy also has a finance background, of course.
Cool. Does that answer your question, David?
To some extent, maybe it's too early to ask it, yeah.
Cool. Does anyone else have any questions? I see in the chat, Gillian. Hello, Gillian. It's good to see you. Saying it's gobsmacking. So I definitely agree with that. Richard.
Thanks, guys, for managing to cover a lot of ground and remain coherent. That was a great job. A lot of questions come up. To frame it, Director at one stage for Eskom was seeming to be open to some kind of discussion of possible trade-offs involving, different units being shut down, and then you get a bit of a break for a few other.
He's frozen.
I think. Yeah.
Of legal processes ongoing,
Sorry,
which is great, because we're obviously gonna have to try and defend the law to the teeth, or whatever the expression is. But I'd still like your thoughts on whether there's potential for, this could also apply to SASOL, some kind of political push to complement what's happening on the legal side. And so, yeah, I mean, if it's possible to get a kind of readout on what's happening with the lawful people, and we can then complement that with, and this is why we've got to make sure that the people who are going to be making the legal decisions are well informed, because it seems like, improving people's access to information making these decisions would probably be good. Thanks. I'm not sure if that was a question or more just a musing.
And Ntombi, you can talk about LAC's position in relation to the trade-off suggestion. in the
Yeah,
MES project?
Yeah, thanks, Robyn. And thanks for your question. Yeah, we're finding that it's becoming increasingly difficult with the energy crisis and the load shedding. So you might have noticed in my presentation, Eskom has used this a lot to say, like, at some point they said that if they do comply with the MES, we'd go into stage 16 of load shedding. And I think the MES forum also agrees. So it's actually becoming way more difficult. Yeah, just politically. And the LAC has maintained the stance that, you know, we shouldn't look at it as a trade-off between having electricity and having clean air. So yeah, that is something that we continuously try to push from our side, even though it is becoming increasingly difficult.
Yeah, I mean, of course, the argument is extending the life of coal-fired power stations. Surely that has implications for our JETP funding and the like. And I don't know, from the political statements I've seen, they're like, no, it's all cool. Everything's fine. It's under control. Yeah, and as I say, these are the same arguments that have been raised since the very start of the process. If you force us to comply with the law, there will be load shedding, and they weren't forced to comply with the law and there was still load shedding. So it's extraordinarily complicated, and we hate this balancing thing, but that's exactly the argument, you know. You can choose, do you want electricity? And SASOL is, you know, a very accomplished lobbyist, as many of us on this call know. And they say, look, we already comply with 98% of the emission, the MES. It's only SO2 and it's only a small amount. You know, we're integral to the economy. So many jobs, biggest government taxpayer, we're doing our best. And this is the only way we can meet our GHG commitments as well. So it becomes extraordinarily convoluted.
Thanks for that, guys. And Jeff?
Yes, thanks. In a sense, extending your question, Richard, beyond, well, the political, what, if any, contact has been made, is being made with local communities, those directly affected by the shenanigans that's going on forever and ever? Thank you.
I'll just come in there. So as LAC, we do usually engage with communities as part of our advocacy on health literacy generally, and we have awareness workshops raising awareness on health literacy and health advocacy around air pollution in Mpumalanga in the Highveld. So we also work with smaller community-based organizations like the Vugani Environmental Movement, which was our client in Daily Air. So we are keeping those conversations going. Yeah, it forms part of our work as LAC.
And of course, through groundwork and all of their partners as well, this is work that's being, you know, informed by communities on the ground who are, of course, suffering by far the worst impacts, which is also the political issue of, you know, weighing up electricity versus lives of predominantly poor people in Mpumalanga.
May I follow up with another question?
Just because I like you, Jeff, go for it.
Just with what response from your community engagement? What, if anything, are they doing? What, if anything, can they be doing? What, if anything, should they be doing? Thank you.
You want to take that, Yogeshni?
This is not why I had my hand up, but I can give it a go. Yeah, I think thanks, Jeff, for that question. I think it really is critical in terms of the groundswell of community support. So mobilization is key. I know that they have been putting pressure on the local government, the municipal offices, as well as the DMRE office, which is located in Mpumalanga. So for us, that's part of the solution of actually mobilizing on the streets so that government can realize that, this is a demand that's coming from the grassroots level and not just from civil society or NGOs or privileged people. And I think another level of that, as Ntombi mentioned, is the health literacy. So actually starting to involve people in creating their own arguments around health and air quality and environmental justice, so that when they are called forward into comments or interviews, any kind of news or media interaction, they're also able to articulate these demands, but also trying to bring them into spaces where technocratic arguments dominate. And I think that was related to the comment question that I wanted to make, is that the NECA forum was a highly technical space. And the only people that could engage there were people who were familiar with the scientific arguments that were being presented. And I think one of our pressure points should really be to the ministry to say that you need to be able to articulate these arguments in a way that the people who are directly affected understand them and can interact with them, so that they can respond to that argument with their own argument. And I think that's been an extreme shortcoming with regards to the postponement applications, because they're prepared by scientists, by modelers, by technical professionals, but there's no requirement on them to actually simplify that. If you looked at that Eskom MES postponement meeting that eventually had to be cancelled, why were there 5 people sitting in the audience? It's not just because they were told the same the day before that there was a workshop. It was also because they're not able to then unpack those arguments. The people who put up those slides are not relating them to people with impact on the ground. The CREA modeling study said that 70 extra deaths would take place. That is a figure that people understand. So we've got to constantly push back on the technocratic arguments that allow people to exist in that space. That coffee slide was so useless. I didn't even understand it myself. So, we have to really bring these critical arguments through to them to say that the people who are being affected are not integrated into this argument. So I hope that helps it. That was just a little bit of the way that we're trying to do this, but it really needs more input from the department as well. Thanks.
Awesome. Thanks so much for that, Kashnia. I think it's nice to have you in the space and kind of in the I think continuously within because it's something that we've been working with at ACA, African Climate Alliance, with the Council Cold case, which about, is making policy personal. And so it's definitely needed, especially when we talk about what does meaningful public participation look like, and the voices of communities, the will of the people being reflected in decision making. So yeah. Last point, I'm going to say Richard, and then maybe if there's one last hand, just because I've given an hour to a 30-minute presentation, but just because it's more important than what's rest on the agenda. So Richard, go for it.
Thanks so much. And this does also relate to something which will come up later in the agenda. It's to clarify, when I was talking about trade-offs before, I was really not clear about the technology retrofits that Eskom has contemplated and costed for compliance. At one stage, there was some discussion of, well, it's going to be prohibitively expensive to do all of them. So if you prioritize 1 or 2, they'll operate for longer, and you shut down the other ones quicker, maybe you can come to a equivalent rate of harm. So to make some retrofit make sense, if you like. So I'm just wondering if you've got any more insight into whether that is still in play, what Eskom is proposing by way of retrofits to some of the bigger, longer running plants. Thanks.
From what the sense I got, they're not planning to retrofit the older plants. So like your hydrinas and so forth, because they're already at the end of their life stage. So that's why they had asked for suspensions to maybe have them running till like 2030 at alternative limits, because they say it's not feasible to retrofit. And then I think for Tutuka, because there's really a problem at Tutuka, and it's like a midlife power station, if I'm not mistaken, they've proposed to shut it down earlier. because they're not able to retrofit. So yeah, I'll just have to double check and get back to you. But that is what I remember their plan being, sort of around the retrofitting.
Yeah, there's a whole detailed table of which ones will have which retrofits at which time.
Richard, does that answer you? Or does that assist in somewhat?
Yeah, I guess if I go to the CEO website, I might, that table would be of great interest if you share it. Thanks.
Are you scrapbooking, David?
He's building an archive of memory that you'll never know about. Okay, Yogeshini, 1 minute, and then I'm closing the segment.
You did allow space for one more question. I think a question I think to the broader group is really around the JETP as well. So there was dedicated funding in there around decarbonization of our electricity sector, which I assume is money that's going to be directed to Eskom some way, somehow through the fiscus. But really the the non-delivery of that funding and the seeming ignorance of the partner group about actually facilitating that part of the JETP. I mean, that also needs to be something of our conversation, because, we are pressuring Eskom as civil society, but we also need to understand that there's another section of the argument which involves pressuring those who should be supporting Eskom through the transition as well, because, at the end of the day, unfortunately, what happens to Eskom happens to all of us, which is such a reality of it.
Thanks for that. I think a good note to close this segment on for right now, leaving room for more. And so I'll definitely keep you informed, Ntombi and Robyn, just if there's hunger for a deeper session or something, we can maybe plan it out. But a massive thank you both for kind of diving into the depth that you have, and helping us kind of understand where we currently are with it. I definitely think it's going to, a lot more questions will come, and I'll try my best to either direct them to you or to filter them and then to send them to you. But I'll communicate that much in the minutes as it gets out. So massive thank you to everybody. Ntombi and to Robyn for giving us time today and sharing a plethora of knowledge.